Hello, everyone, whatever time of day it is for you. Welcome to Litera's 2022 M&A Due Diligence Global Trends webinar. Today, we're going to deep dive into of-the-moment issues facing M&A attorneys, and our powerhouse guest panel will share how they are leveraging technology during due diligence through the closing cycle to combat issues such as sky-high deal volumes, shortened timelines, and retention issues. I'm your host, Valerie Panaccio. I manage our workflow practice advisor team here at Litera. The practice advisors are a group of former practitioners who connect the dots between the practice of law and how Litera's workflow solutions can help. These solutions include Kira, which is our AI-empowered contract review platform and recent joiner to the Litera family, our transaction management solution, Transact, and Litigate, which is our litigation management platform. So before I introduce our esteemed moderator and prominent group of panelists, let's take a moment to reflect on the past year in M&A. Spoiler alert, 2021 was a historic year for M&A, and it doesn't appear that M&A activity will be slowing down anytime soon. So let's review the numbers. In 2021, the number of announced deals exceeded 62,000 globally. That's up an unprecedented 24% from 2020. Publicly disclosed deal values reached record highs of 5.1 trillion US dollars. This includes 130 mega deals with a deal value greater than 5 billion US, which is a staggering 57% higher than in 2020 and smashing the previous 2007 record of 4.2 trillion. Europe, the Middle East, and Africa showed the greatest growth in deal volumes compared to the prior year, with an increase of 34%, followed by the Americas with 22% and Asia Pacific with 17%. Although the volume of deals in 2021 was approximately the same across the three regions, deal value was more heavily weighted towards the Americas, with over 50% of deal values and approximately 60% of mega deals. A recent DataSite survey revealed that 48% of the 600 deal makers surveyed believed that global deal volume will increase in 2022, and 27% believe that it will remain the same. However, respondents also surmised that inflation, supply chain, labor shortages, and ESG are expected to be the biggest deal blockers. However, although 71% reported that inflation impacted an M&A deal on which they worked in 2021, it was still a record year, and deal volume does not appear to be cooling down in 2020. But increased deal volume creates and amplifies increased risk. Risk increases with higher deal volumes because timelines are becoming compressed. There's a need for speed to execution due to market uncertainty, and valuations are more complex and uncertain. Gone are the days where an analysis of just the financial and legal documentation was rigorous enough. Now the scope has expanded to areas such as human resources, data privacy, cybersecurity, intellectual property, tax considerations, COVID compliance, and proof of environmental, social, and governance policies. This results in more risk exposure and the need to identify these risks during due diligence. Unfortunately, a traditional approach to a large due diligence project might involve reviewing somewhere between 20,000 to 200,000 documents, which could take, at the upper end, more than 50 timekeepers, approximately 1 year to review. But you don't have a year to conduct a review, or even a fraction of that. And as we previously noted, those timelines are shrinking. Also, considering that we're in the midst of the Great Resignation, you may not even have the headcount. And what headcount you do have is surely feeling the burnout. And your client may have budget constraints. So even with a super heavy lift, a 200,000 contract review would reveal only what was in about 20% of the documents. But what about that other 80%? Should we just decide to look at samples and hope for the best? According to Compliance Week's Inside the Mind of the CCO, 25% of compliance risk professionals said that lack of support and resources is the part of their job that keeps them awake at night. And we need to also consider the risks attendant to the closing process, which comprises heavily of low-value administrative tasks where the risk of human error is high and very costly. So that's where adoption of time-saving technologies and alternative data will help in 2022. Thus, it should come as no surprise that the use of technology in legal is on the rise. So about 3 years ago in December of 2018, DataCite released the results of a poll of 400 deal makers around the globe. According to the report, only 22% of respondents said that technology was the driving factor, driving the most change in due diligence. The reports also indicated that technology was poised to solve a number of problems in due diligence. So only about 30% though of respondents said technology would help address document self-organization and project management, while 29% chose contract review, analysis, and redaction. So let's see if these 2018 predictions were correct. And I realize that this is not the same group of respondents, but responses to Deloitte's 2022 Future of M&A Trends survey demonstrates that tech currently plays an even greater role in M&A than envisioned just a couple of years ago in the DataCite survey. And I can't help but wonder if the pandemic played into that. The Deloitte survey polled 1,300 executives at corporations and private equity investor firms in August and September of 2021 to glean insights about current deal activity and expectations in the next 12 months. A staggering 69% of respondents reported that they are currently using data analytics in their diligence and monitoring, and 27% are considering adding those capabilities. And also, let's face it, remote work in some capacity is here to stay, whether that be working from home or collaborating with colleagues across the firm's geographic footprint. Respondents in the Deloitte survey were asked, how do you expect to manage the following deal elements over the next 12 months? For due diligence, 57% reported that they expected to perform these tasks virtually, and 26% said that they would perform due diligence in a hybrid fashion. For transaction execution, 58% reported that they would perform those tasks virtually, and 23% that they would perform transaction execution in some hybrid fashion. So in short, and at the risk of sounding reductive, now is a very exciting time for technology and M&A, and I could not think of a better group to share their recent experience and further explore trends in due diligence than the group that we have today. So on the panel, we have Michael Francis. He is the managing partner of Weil Gottschall's London office and a member of the firm's management committee. His experience spans across all public and private transactions, both domestic and cross-border, and across a range of industry sectors. He is ranked in Band 1 for private equity and M&A in Chambers UK 2021, and as a market leader in IFLR 1000 UK 2021 for private equity, M&A, equity capital markets, and investment management. He is the only lawyer in London to be ranked in the Hall of Fame category for both private equity and M&A in Legal 500 UK 2021. Among his many accolades, Michael was deemed the most general counsel recommended private equity lawyer in the UK by The Lawyer, and shortlisted as one of the UK's top innovative lawyers in the Financial Times Innovative Lawyer Awards. And he was also listed in the Times Law 100 UK's most powerful lawyers. We also have Dr. Holger Hofmeister. Holger is an M&A partner in Skadden's Frankfurt office. He advises corporate and private equity clients in connection with acquisitions, divestitures, public takeovers, joint ventures, and other M&A and corporate matters, including capital market related aspects. He was named in Wirtschaftswoche as one of the best corporate lawyers in Germany. In addition, he has been named by both Handelsblatt and Wirtschaftswoche one of Germany's top M&A advisors. Holger is also listed as a recommended lawyer in Juve and was listed in Best Lawyers in Germany in 2021. Then we have Rita O'Neil. Rita is a partner in Sullivan & Cromwell's Los Angeles office and serves as co-head of the firm's global private equity group. She has broad-based practice that includes advising clients on mergers and acquisitions and securities offerings, and providing general corporate advice on disclosure and governance across a wide range of industries. And like our other esteemed panelists, Rita has many accolades, just too many to name today, but include being recognized by Chambers USA for corporate M&A private equity in 2021. She was named among the Los Angeles Business Journal's 2019 most influential private equity investors and advisors, and Private Equity Lawyer of the Year by Euromoney's America's Women in Business Law Awards. And I'm excited to share that moderating today's discussion is Noah Wasteberg. Noah was the CEO and co-founder of Kira Systems, which is now part of the Latera family, as I shared earlier. And while Noah still serves as a strategic advisor to Latera, he launched Zuva, which focuses on NLP document analysis for corporates. Prior to co-founding Kira Systems, Noah practiced at the law firm of Weil Gotshal in New York, where he focused primarily on private equity, M&A, and securities. Noah is known as an expert on contract analysis, legal technology, and artificial intelligence, and has spoken at conferences including South by Southwest Interactive, ILTACon, and reInvent Law. And he's been named the Financial Times Intelligent Business Market Shaper and ILTA's Innovative Thought Leader of the Year. So we're going to take questions at the end of the panel. And if you have any questions about any of the products that I described or any of the issues that we discussed, please feel free to visit us at our website. And so with that, Noah, take it away.
Hey, it is good to be here. I apologize to the panelists in advance, but I am on sort of holiday at a ski resort, and so any kind of weird lines that you see on my face are due to goggles. But anyways, it's great to be with you. We have a really good panel, and the last two times that we've had this kind of same conversation over the last year with some slightly different panels, they've been really fantastic. So I'm optimistic, knowing the other people who are on here, that this one will be too. With that, I'd like to start out with a pretty general question. So we're going to be talking about diligence, and my first question is just, where should legal diligence focus, and what do you think good diligence, smart diligence spend is? We'll start with maybe Rita, since I can see you, and Mike, I'm sorry we can't see you, but no stress. We had this happen the last time, actually, to one of Rita's partners, Steve Cochran, who's a super smart guy, so I wouldn't feel too down about not being able to see you. I'm sure we'll still get a lot of really great contributions out of you. Rita?
Thanks, Noah. And since you're apologizing for the ski band on your forehead, I'll apologize for the Los Angeles sun starting to pour in as we get near 80 degrees today.
Yeah, and it's like, big thanks for doing this early in the day.
No worries. So I think, thinking back, what the most important things of diligence are and where to focus the time, I think we'll be spending a lot of time today talking about the interplay between diligence and how it's changed over the years in connection with rep and warranty insurance and that process. And so I would start off by saying that good diligence hasn't changed as a result of the rep and warranty insurance process, and it is still paramount to focus on the most material provisions. And I know Valerie said in the introduction, so once we get to, I think everyone agrees we should focus on the most important and the most material, and we'll be spending a lot of time talking about the other 80% or so. But having a interactive dialogue with your client, hopefully having a call with the target to understand what they think is the most important in diligence, and then really working with your team to focus on an efficient but targeted due diligence process.
How about you, Holger?
I think I can only echo that. I guess the smartest diligence is the diligence that you closely coordinate with your client, because usually client knows kind of where to look at, where the pitfalls are. Then you go into it and analyze it. So from my perspective, preparation is key. And preparation, of course, involves also partner time. And once kind of you've figured out kind of where your focus should be, and it might be different things, right? I mean, you have usual suspects, I guess, right? Kind of litigation cases, material, commercial contracts, stuff like that. But each transaction is different, and each focus then will be different. So preparation is key, and you really talk to your client and need to coordinate with him in advance.
And Mike, what about you? What do you think?
I think being third isn't a good place to be, actually.
Well, I feel like
so I obviously agree with what Rita and Holger have said. I think the key for diligence in modern deals is that we've gone away from the kitchen sink approach, review every document, do a summary of it, and let the client make decisions. I think the client expects advice on diligence now, what is important, what isn't important. To give that advice, you need to understand the business that's being bought, but also what the client's aims are in buying it. So again, I'd repeat, I think preparation and knowledge, and actually judgment and ability to exercise judgment, which means maybe more senior people are being involved in the diligence product than were sort of 5-10 years ago.
So if you think about like what's important in diligence, right? Like there's a certain set of things that are pretty obvious, right? Like obviously the kind of largest contracts, environmental stuff, maybe today, like pension stuff. Certainly litigation's a pretty easy call. You might care about some IT or any regulatory investigations. But the thing I think about most, just because of my background, is contracts. And the thing that's always kind of perplexed me is how you can know what the material contracts are without reviewing them, right? Like, you know, certainly some of them are obviously material just because of their size, but there's other ones that could be material because of content. How do you sort of think your way around that? And I see Rita nodding here, but I'm going to go after Mike since he was complaining about being third first, and you know, that's what the umpire.
I'm not sure I was complaining. On reflection, being third isn't so bad. I think it's really just what I said before. I think obviously, as you're right, you know, certain amount of contracts and material simply because of their size in relation to the business. You know, people often have the 10 or 20 biggest suppliers or customers. But I think how you can identify the rest is really by knowing the business and understanding what might not look like a lot of value, but is important to the business. And to do that, you've got to work closely with your client, but also understand the materials you have about the business being bought. And yeah, the chance, and if you look at the commercial diligence, the client does the commercial and marketing reports, the financial reports that go with the legal report. Out of all that and the client's knowledge, you should be identify things that are material, not just on value.
So Rita, how about you?
Yeah, so I think that one, dialogue with the target if you can. I mean, our preference is always to have a call with the target and talk to them about what their contracts are. Obviously, the ones that are, you know, exceed some annual turnover or revenue threshold are important. And then also, if you think about the reps and what we're going to ask them to schedule, any contracts with MFNs, contracts with sorry, we just all got very big. Valerie, did you stop screen sharing?
I did. I realized the question was on, and I didn't like that.
Okay.
Apologies.
And so if you think about that rep of material contracts, all of those are designed to tailor what is important and what's a material contract in a purchase agreement. So government contracts, contracts over, you know, that bind you to non-competes or pricing volume restrictions or take or pay, all of those. And so you have one, the conversation with the client and the target. Two, you have a conversation regarding revenue thresholds for material contracts. Three, you have that extra proxy. So really, no, I think you're like, well, what about the missing category that you don't know? And that's when you know, hopefully in a call or asking outside of the ordinary course, what's an agreement for you that you think is important but doesn't hit any of the other categories? And so then the question is, would a review, machine learning, you know, AI review of all of those extra contracts actually show that something's material in there if you don't know what to tell it to look for, right? And so it is very interesting, you know, is there a smoking gun in a contract? And I can give you an example of one that maybe would have been picked up in an AI exercise, which was a restriction of a non-compete that bound affiliates, but it was worded in a way that wouldn't sort of fit your normal formulation. And that contract years later wound up being something that did cause some agita for the client, and, you know, definitely tailored how we would think about those restrictive covenant type agreements.
So Holger, I'm going to ask.
Diligence that one, but but we inherited it.
Took over with some other firm that's not on here, messed up, right?
No, I think from my experience, I guess the traditional way, if you will, I guess brings you pretty far still. That's my experience. So meaning really good preparation, of course, talk to the target, really make sure you understand the business, you are in close touch with your client who usually kind of knows the industry or has advisors who can help you kind of understanding the issues. And then I guess you focus and look through the diligence index, see what's there. And then start asking the questions, right? What would you miss? What else should be provided? But I fully agree. I mean, there may be things that you simply don't spot, right? And that's the risk analysis. You need to talk to the client, make sure they understand kind of where the gaps may be, what options you have potentially to close those gaps, and then kind of the client makes an informed decision. And of course, we guide the clients, we give advice to that. But kind of that's ultimately how you go about it generally.
So Holger, I'm gonna, Rita and Mike are not gonna make answer this, but one special add-on for you, which is you're one of the few partners I know who's been involved in a sort of comprehensive diligence where you reviewed like everything over a set of a few million contracts. Did everything kind of turn out the way you expected in that project? Feel free to talk about the project at all if you feel like it, or not, if you'd rather not. But I think you guys have written a piece on it, so you probably could, but it's up to you.
No, I think it's perfectly fine. I guess indeed it's no secret. So it was an internal reorganization. What was meant by that is first the documents were all available kind of with the client. It was all kind of client proprietary documents. And who were stored on a huge database, and it grew over time. So ultimately, I think we reviewed about 4 million documents, I think. And I think eventually, of course, we spotted some things here and there, but I guess ultimately it turned out no huge surprise, but you didn't know before, right? And because the project was very important to the client, we had a lot of discussions with the clients on how to tackle that, because it could have been that there were clauses in agreements in particular that they entered into. That was a huge universe of agreements where you want to make sure, you want to know what you need to do. Not everything was centralized, so the first step was kind of really to collect everything before you can analyze. And that was part of the issue, because the client then felt very comfortable once kind of everything was collected, and then we had the review with the software tool. And I guess ultimately everyone was pretty happy. Everyone had a nice sleep, I think, because we had that search, and we discussed the risk with the client. The client was fully aware of everything, what happened. He digged into that pretty thoroughly from the outset. So I guess in that project, it turned out to be a huge success, to be honest.
Noah, I'm going to interrupt here for a quick second. Just, I would think sure. At the end of that process, you would probably then also have a pretty good contract management system coming out of that, right? Because you're diligencing it, but then you are aware of everything in your contracts going forward. But you're doing a maybe not, Noah.
Well, it depends, right? Like I think if you're doing diligence and you're trying to be pretty efficient, you're probably going to try to just focus. Like you're going to focus on a limited number of issues, maybe over a wide scope of contracts, right? Like maybe change of control. I'd actually probably not bother too much with change of control and assignment, because if you blow it on a non-high dollar value contract, it arguably doesn't really matter that much. Things I'd be more worried about would be like, like non-compete, exclusivity, MFN, like anything else, maybe like limitations of liability or indemnities or things like that, where maybe non-solicits, like stuff that could go really wrong in a bad context. And so, in fact, like you might or might not have a great contract management system at the end of it, because like you'd have a great contract management system on a limited scope of things. But I think, like you would know that super well, and you'd know that there was like a weird non-compete or like the affiliates binding language in something where you didn't expect it to be. But in a contract management system, you might care a lot more about like pricing and like inflation adjustment clauses right now, and maybe like force majeure if you've got like Ukrainian like Latera development people, which is not like a bad, like not to rip on Latera at all, right? Like just like those are things you might care a lot about in a contract management system. And I think the non-compete stuff would be useful too, but like 6 of 60 data points that you're looking for.
Got it.
Though that's an interesting, it kind of like, this wasn't exactly where I planned to go next, but it is an interesting, there are some companies that are kind of proposing to sort of combine the post-merger integration and diligence phases. Like, do you find that your firms, like, so we have not exactly a diverse sample of firms in the sense that S&C, Skadden, and Weil are all pretty high-end places, right? But do you find that you all are still doing the diligence, or there are places that are proposing to do what you're describing, Rita, which is find assignment, change of control, and non-compete, but also find all that kind of other stuff? Do you find those are coming up in deals that you're working on? And let's, I feel like going to Mike again, because I still feel badly. The third thing is stinging me, and I think by not being able to see them, we're a little bit more likely to do that to them.
I guess I don't really see that as much, to be honest. It sounds an interesting idea, but I think what you were saying is, do you find that we are not doing some of the diligence because it's being done by people who are more conscious of the post deal integration?
Yeah, or just like, are there other people? Like, I remember when I was at Weil, like we were doing the diligence, but I also remember at the same time my colleagues who were juniors in litigation were doing all the e-discovery work. And now my sense is at Weil and places like it, the juniors aren't doing so much of the e-discovery work. Has the same thing sort of played out in diligence, or not real? My sense is it hasn't, but I'm curious to see if you.
Well, I guess it hasn't. It hasn't for us. Whether it has with other people, I think we are seeing a lot more focus on our diligence of product in people wanting to know what they have to do, what they should be looking at post closing. But that's still really from our point of view rather than anything else. Others might have a different experience.
Rita?
I feel like I'm monopolizing. I must be like top right on your screen or something. So I totally agree with Mike that you're not seeing the same pickup as you have in the e-discovery, and you're correct that there's an e-discovery team now, right, at S&C, and we use all kinds of software and technology and outsource, but you don't have that on the diligence. On the corporate diligence side, I do think there's, depending on the nature of the buyer, for our strategic clients, we do often have an interactive discussion with them about splitting up review of certain documents so that they're reviewing more the integration type thing, and then they're able to merge. They'll have us put our results into a Excel template that they can then just put into their, it also add to that template. That's probably the closest thing that I've seen to what you're talking about. No, and we do have sometimes, and we just did a deal. It's always nice to talk about this in advance with the client, or at least keep them updated with the scope creep on diligence, but where they did ask for a lot of pricing and volume and information for us to summarize that in the agreement, which obviously isn't the most efficient, but particularly if you're private equity and you don't have a team that does that, you do need someone to do it. So that's a situation where maybe we weren't in the best position, or our legal skills weren't being used for that, because it's mostly just extracting the data.
Nice. Holger, how about you?
Yeah, same from my experience, to be honest. So that hasn't changed much. And I guess even if you're on the sell side, right, and you usually do also a fact book, a legal fact book, vendor DD report, what have you. So I guess same thing.
How? So Rita kind of alluded to this a bit earlier, but I'd imagine rep and warranty insurance is a big thing in your deals these days. When we sold Kira to Latera, which Skadden was on the other side of, for what it's worth, representing Latera, we use rep and warranty insurance, and my sense is it's become fairly ubiquitous in parts of the market. So question number one, am I correct that that's so? And then the more interesting part, how do you find, has that impacted how you're doing diligence at all? And just to keep things interesting, let's start with Holger.
Nice. I'm totally surprised now. I guess coming to your first point, it absolutely is increasing. It's definitely on the rise. So W&I insurance, I think it started out initially mostly with PE sponsors, right? When they sold something, wanted to exclude their liability. But I think now we are seeing it all over. We are seeing it even now if big corporates sell portions of their business, and they usually reduce their liability for operational warranties to €1, right? So that definitely is something that comes up more or less in any deal, and in various situations then. So either you have it stapled, so the seller kind of makes already proposals and have sampled some offers from insurers, or you need to take care as the buyer on the buy side. What does it to diligence? I think it hasn't done much other than making people really aware of that diligence is an essential part of getting reps and warranties insurance. And usually the insurer, they have their own people who do diligence, but they definitely carefully review the diligence reports that the buyer is producing and is asking for from its advisors. So if kind of your question would suggest that there would be less diligence because the insurer takes it all, that's not the case.
Actually, my experience was entirely the opposite.
Exactly, that's what I wanted to say. It's directly the opposite, because you can only be safe in really obtaining the insurance if you did really a well thought through due diligence and really documented it in a organized and really state-of-the-art manner, meaning a due diligence report that is reasonably sufficient to the insurer. So in that respect, I think focus is on diligence, and you need to do it smartly, because indeed on the one hand side you have to balance. You usually don't want to look and cannot look at everything, so you need to focus, but then you have to make the right choices to make sure that what you do, what you look at, and what you write down in your report really is sufficient to the insurer.
Mike? Mike, are you able to hear?
Hello?
Hey, yes. Do you find that reps and warranties insurance?
Sorry, I'm having trouble doing the unmuting here.
Yeah, no worries at all. We're not you're not on here for your skills with GoToWebinar, but actually because of your sort of insight and experience. What do you? I don't know if you heard what my question was before, but just I was wondering if rep and warranty insurance is sort of changing how you all do diligence and how you, as someone who's sort of leading deals, thinks about it and talks to your clients about it.
I think Holger said, which I agree with, has become the norm. So it changes in a bit, in a sense. Some of the diligence is suited to fit in with either gaps in the insurance policy where you maybe do more diligence, or the insurer's views on your scope. But I would say actually last sort of 6-9 months, people are having a little bit of a rethink. We're seeing a bit less reliance on diligence, and also on insurance. It's also proving to be harder to get insurance to cover what you want to cover in the market. So I think has an effect, but in my view, not a major effect.
Huh, interesting. So you're seeing less use of reps and warrants insurance these days than you would have.
Less. I think it's still in almost every deal we do, but less reliance on it, and more going back to insurance is part of the protection rather than all the protection.
Interesting. So is that you just can't get, the insurers are carving out some things, or?
There's some kinds. I think there's been so many deals, and there's just a limited amount of coverage in the market.
Interesting. Neat. So Rita, what are you seeing?
So I would agree with Mike. I think especially at the end of 2021, where there were bandwidth issues at the insurers, and there were a lot of them had hit their quotas for the year and were at capacity, and just burnout. It was a lot harder to get rep and warranty insurance at the end of the year, We're not seeing that now, but what we are seeing is insurers being a lot more specific about exclusions and contract language based on their claims experience. And then also seeing certain industries it being a little bit harder to get coverage, certain types of healthcare, and that type of space. And then also privacy, we're just seeing a lot more exclusions in those, or harder diligence. And so, like Mike said, what we're doing is we're actually being prepared to get indemnities to backstop some of those issues. And then also particularly in some smaller deals, going back to a full escrow, because they don't want to deal with the claims process. That being said, reps and warranty insurance is still everywhere. And in terms of how that's changed diligence, I think both as Holger and Mike said, you're diligencing to find the things that could be excluded. And then you also, there are, our clients are highly focused on other things that may not squarely fit into a breach of a rep, or something that might be reputational, or something that might have such large consequences or could go up the chain, like environmental or anti-bribery, anti-corruption, trade, export, trade controls, export, import. Any of those, I do think that there's a heightened focus, and then also anything, that could cause reputational harm.
So I'm going to ask one more question, and then there's going to be some combination of audience questions or questions from Valerie, and I'm not positive which one, but and I can ask more too. But Rita, you were talking about burnout at the insurers. I'd imagine you're also seeing some of that at your own firms. How do you think, like, diligence wasn't my favorite task as a junior, though I probably enjoyed it more than most, since I found it kind of interesting to learn a lot about the businesses. How do you find that's kind of playing into the way, like, I'd imagine your firms have all been pretty busy this past year, and you've probably faced some level of attrition, maybe less than at other places because you're such wonderful places to work, but nonetheless, probably have had some more attrition than you'd like amidst like a fair bit of busyness. How do you find that kind of plays into what you're able to do in terms of diligence for your clients? Like, are there ever situations where you're not able to come through? Does it impact how you think about things broadly? Like, does it impact timelines, anything like that? We'll start with you, Rita, since I don't know. Here you are, top left.
Okay. So I think a couple of things. Obviously, yes, everyone, not just associates doing diligence, I think are burned out from 2020, 2021.
This is my first vacation since 2020.
Exactly. So I do think it's very broad. I don't think it's affected our due diligence. We'd rather not take on a deal if we couldn't handle the capacity of doing a thorough diligence process. Even before this incredible boom and the pandemic, if somebody was buying a company that had 500 leases, we would probably have a conversation with them about bringing in another firm to target and do those leases. A lot of our clients also now are using regular corporate counsel, sort of their day-to-day counsel, where we're coming in as transactional counsel, and they're using that sort of their regular day-to-day counsel to help with some of the volume of due diligence, which is helpful to us as well. And all three of the firms you have on here, again, you didn't pick a great cross-section of firms, but all three of us are very familiar with playing nice in the sandbox and working really closely with other counsel advising our clients. And so we're all very self-aware of what our best use is on a transaction and where we can talk with our client about ameliorating some of, and alleviating some of the burden, and then a cost, right? I mean, it's a cost issue too for the client. But taking all that, it is an incredibly appealing prospect, particularly for first-year associates, with some sort of AI technology supplement to help with diligence. I think us, and again, not to speak, although I do know because I work very closely with both the other firms on the call, it has been hard to get our clients to adopt that. Whereas it's interesting on the e-discovery space, there seemed to have been an idea that, well, and I'm going to throw out a number which Noah you'll probably freak out about, but like we've heard that a lot of times a really large e-discovery project is like 60% accurate. And they're like, okay, well, that makes sense. The cost of doing it, first years aren't that, great, smart. They're probably going to have errors. And so you balance all that together. That's maybe a percentage you can get comfortable with. Whereas on the corporate side, we have not seen that adopted. And now, Noah, tell me your recall and precision are 99% on e-discovery, but at least we've heard a lot of dialogue about that the client is willing to take the fact that accept the fact that the smoking gun might be in a document that's not picked up in e-discovery.
Yeah, like I think actually in the e-discovery one, the numbers I'll send you the citation afterwards. There's this Moore Grossman and Gordon Cormack article. I know this mostly. Our current head of research at Zuba used to be a grad student of Cormack's, but I think in their research they found that the e-discovery technology might have been like 68% accurate, but the people were only 60% accurate. I think in the corporate numbers are higher, but I do know in AI for Lawyers, which I sadly don't have a copy of to hold up, Shearman was saying that they found that their diligence was more accurate using Kira. Anyways, putting that as that was not what I
have your book on my mantle, but I didn't have it.
I have it in a random bag here at the Hill for a weird reason, but I have to give one as a gift to someone that I'm seeing later in the trip. But normally at this point, I would be holding it up and showing it off. Alas. So, Mike, lest you be third the whole way through, what are you seeing in terms of attrition and how that attrition, burnout, and how that?
I don't think attrition and burnout is anything to do with diligence, personally. I mean, lawyers at all levels have been, and including the business services and staff who support them, have been working at incredible levels for a long time. And I think everyone is facing the same problem, really, that people don't want to work at those levels day in, day out for the rest of their careers. I think from our point of view, we do have clients or firms we use for diligence where clients, frankly, don't want to pay our fees on diligence, and actually where it's not worth them paying our fees for a lot of the more routine diligence. But I think that's not to do with burnout, that's more just to do with deal efficiency. In terms of burnout and I guess keeping associates happy, our best use of technology is not so much AI tools as such, we think, but making sure that technology actually works so they can have flexible working. They don't spend half their time redoing stuff or recovering lost documents or not being able to connect. And frankly, looking after people, recognizing it's not just about money, it's about the other things you do and recruiting. So if there is a magic way to help, I'd love to know it, and I'm all ears, and I'm not scared to say we'll copy it. But we haven't found it yet.
Yeah, I think ultimately if you have people working 16 hours a day, 6 days a week, they're going to get pretty burnt out.
Obviously, like every firm, we're an organization, we're very focused on the wellness of our people and catching things early and making people aware. And you just have to carry on doing the most you can do.
For sure. Holger, you get the last word on my questions, but then there may be some others.
Yeah, no, listen, I think it's basically all about kind of organizing yourself, right, and your teams. And I think the measures, I guess, we have been applying for a couple of years, and I think it's exactly what Michael said. It's about efficiency, right? So you can do it yourself. You can kind of see whether there are any specialist firms that the client also knows for a long time. He trusts them, and they do some of the work. You have local counsel to a certain extent who do their work, of course, and then you have the client itself, right? And there are usually, from my experience, the client always gets involved with their own people in the diligence. So that makes you kind of be looking only at a certain pieces of a specific area where the client definitely has own expertise, at least when you talk about corporate clients, right? It's different for PE. But kind of that's the picture I think we see, and with which we got along pretty well last year.
Thank you. Valerie?
So everyone, if you haven't yet, please submit your questions into the chat, and I will be sharing those with our panelists. But while we're calling our questions, let's start talking a little bit more about tech. And just like Noah, I also like to start with something a little bit more general. And when I think of technology, you can't really think of technology without thinking of the problem first. So what are some of the shortcomings or pain points in performing due diligence without the assistance of technology? And Rita, you're going to be on the hot seat first.
Well, I think one of the pain points, having been a junior associate myself, is just reviewing tons and tons of agreements that are the same, based on the same form, but are slightly different. And those, I think, in conjunction with discussions with our client, have had conversations about preparing charts that just summarize the differences or highlight the differences. And so that, I would think, is probably a place where tech might be able to help, as opposed to saying, here, read this M&A agreement. But if you have a lot of agreements that are based off of a standard form, I think that's particularly helpful. I mean, that jumps out as me as the biggest pain point, is just volumes of documents that are just slightly different, as opposed to documents that are all very different, although that's a different kind of pain, I think.
And I am not going to make the same mistake Noah did, so I'm going to call on Michael second.
Should have kept my mouth shut at the beginning. The lesson to us all. I guess, diligence is big diligence is a hugely time-intensive and arduous process. So if you look at everything people are meant to review, large number of documents, organize their findings in a sensible way, have it reviewed by senior people and the client, work out how to deal with 50 different people have reviewed the same types of document, or might have looked at them in a different way. So I think technology can help by just making everything a bit more consistent. I think that's one of the advantages. Obviously, it's already helped just by virtual data rooms. I don't know how you do modern diligence without virtual data rooms, but generally, I think anything that helps organizational and making sure you know what you reviewed and that you've been consistent is good, because it makes the process more efficient. So again, I haven't really got much to add to what Rita said, but I think technology is sort of, if you look around businesses generally, technology is helping them be more efficient. And I think it'd be foolish to think that that's not going to happen in law. And diligence is an obvious place. Obviously, one of the key things is for clients to actually accept what you're doing. The use of technologies, the use of the cloud in some cases to store things, and an acceptance of I guess how liabilities work when you use these products. At the end of it, it's really a part of the relationship between us and our client how we do this.
Holger.
Yeah, to me, to be honest, and Mike said it, efficiency is key, right? Efficiency for us and efficiency for the client. And I guess if you use technology wisely, I guess you can get an increase of efficiency. I guess you need to be careful kind of what you're using and in what sector kind of you're using software or other tools that you may have. But really, to make it more efficient, I think that's something that strikes me as really the key point, where you can increase and where you typically have your pain point, because you have all the organizational measures, the allocation of proper staff, seniority to the various tasks that you see in a due diligence. So in that respect, I think technology can definitely help to make things more efficient.
And so this is an interesting audience question. Holger, you had mentioned before your due diligence reports, and Rita, you actually just mentioned charts outlining the small differences between contracts of the same form. So I think it's a good time to ask this one, is how have those reports changed in your experience in light of tech? In light of tech. And Holger, let's start with you, since you were the first one to mention the report.
I think we're looking, to be honest, we're looking at our diligence reports. I think they haven't changed much with a view to the use of legal tech. I think they simply evolved over time because, of course, we're discussing them each time with clients, and things evolve, right? So I guess usually you started out with comprehensive reports, then there was some switch then ultimately to kind of red flag reports, really focus. No one has really time to read a couple of hours through a diligence report. So we really need to make sure these things are short and precise, but of course capture the material things. So I guess from that perspective, legal tech itself, I think, has not really changed the reports by themselves.
And Rita?
You know, it's interesting. I would think it's actually changed more as a result of rep and warranty. Sorry to beat a dead horse here, but of rep and warranty insurance, because where we used to wax poetic for pages and pages of all the wonderful things that we wanted to tell our client, I think now we're much more concise and focusing on the real issues and try to be very judicious about the words that we use. So I don't necessarily think that tech, at least in my personal experience, has had an impact on the type of report, I guess, unless you consider more people being facile with Excel, which I'm not sure is the tech you were focusing on. But I do think that, you know, generating reports, if you were to use some sort of AI product to review all those form documents, it would be much easier to just export out a chart, and that would be different from the normal prose DD executive summary that we would prepare.
Yeah. Michael?
Nothing to add, really. I think the DD reports we've done have evolved to match what our clients are expecting rather than because of any tech or other things. And I think what they're expecting is more advice and more conciseness, right? You know, they expect us to be telling them what to worry about rather than giving them huge reports and letting them read them and decide what to worry about.
Yeah. So what areas of M&A work, aside from diligence, have you seen where technology has made a big impact? And I'm gonna start again. This time I'll start with you, Michael. Michael?
Sorry, am I demuted now? I'm muted now. Yeah, okay.
You're unmuted now.
Well, I guess I sort of mentioned virtual data rooms. They've obviously had a big effect. I guess we don't use them much, but I have seen people using sort of checklists, you know, for approvals and signatures. Obviously, there's you know, electronic signature tools. I know we've tested things like document automation tools. There's a deal point database. You know, we talked about the contract review, but I'm not sure. I'm struggling here, to be honest, you know, other than the obvious one of signatures and data rooms, to say something we see all the time or that's regularly changed things.
Yeah. Rita?
So we too check closing checklists, working group lists, which used to be a real pain to format. You know, now you can just check who you want on the team and it generates it. Our NDAs are now, we have a contract express system where we punch in what we want in our NDAs. And then even our own firm engagement letters, we have a system where you generate our fee proposals for clients. Also, we can say sort of what components are in our scope of our coverage. We do have a due diligence report template sort of floating around that we're working on, which would talk about what types of things you reviewed, which disclaimers. It's largely, I have to say, not so much the substance, but which disclaimers we're including in our DD reports. But that also, you know, what jurisdictions are we excluding? all those types of things. That's still in process, but that still doesn't get us to doing the actual diligence.
Yeah. Holger, do you have anything to add?
Well, I think diligence is the most prominent example, right? I think with respect to the others, to add perhaps collaboration tools, so where you can work kind of in the same document, share various versions of the same document, and you share it not only kind of within your colleagues and your firms, but also with other firms who are working on that matter, and also with the client itself, right? So I guess on that front, there we see developments, collaboration, but I think, yeah, other than that, it's basically, I think, lists and signatures.
All right, so we're down to the last question of the day. Thank you everyone for joining, and of course to our esteemed panel, and to Noah, thank you for generating this really great discussion. I learned so much. Just a fun question to close things out is, what do you think will be the biggest impact that technology has in M&A in the next 5 years? And with that one, I'm going to start with Holger.
Well, I'm excited to see what it is, to be honest. I don't have an answer to that. I'm not sure where it will evolve. I guess, I mean, diligence, of course, will evolve, that's for sure. But I guess the big question is, okay, at what point kind of, and that's, I guess the question everyone's asking, at what point is AI taking over and is drafting and negotiating an SPA? I think that's not going to happen within the next 5 years. So yeah, I'll be thrilled to see where we see kind of the biggest impact in the next 5 years.
Great. And Rita?
Well, I was just thinking about, like, if you look at the last year and a half between Zoom and DocuSign, I mean, those have somewhat revolutionized how we're doing the deal. So really, you know, the world is our oyster in terms of how technology can change. I've talked about previously that I co-chair a project with the American Bar Association where we are doing deal point studies on surveying deal points, so trends and contracts, and trying to train AI to review those agreements. So it could be that we could have some types of diligence or contract drafting in that period of time. I do think Noah would easily say that the accuracy of AI in the M&A space is going to rapidly increase over the next 5 years. And I think a lot of people are projecting in 5 years that we can have contract electronic systems reviewing contracts and potentially help drafting some of them.
Great. And Michael?
I have no idea. If I knew, I'd invest in it. I guess I'd like to think that something will happen with data and knowledge management. I sort of feel that as firms, we have so much knowledge captured in different areas and so much data, and we don't really necessarily make use of it. We still repeat ourselves. Anything that will help us be more efficient to our clients will obviously be helpful. I would be surprised if in 5 years' time, instead of us saying, the equivalent of this panel saying, you know, we use the AI sort of diligence tools now and again off of the right projects, I'd be surprised if it hadn't become the norm as they evolve and they get more and more, you know, information downloaded to them to make them more accurate. It seems it's only going to evolve more.
And I can't help myself, but Noah, what do you think is going to have the biggest impact in M&A in the next 5 years?
So I'm skeptical that we're going to see much drafting, maybe some negotiation of merger agreements. I don't know how much drafting we'll see. I think we'll see drafting informed by deal point studies that will be put together with AI, and I think there's a bunch of firms who do that right now as it is. I think on diligence, I agree with Mike that technology, automated contract review will be ubiquitous. I think it's going to, I've actually heard it said by the general counsel of a large firm that he felt you could even probably bring a malpractice. He didn't know if you'd win or lose, but he felt that you could probably raise a malpractice claim now if someone didn't talk to their client about all the information that might be missed by only doing a narrow review, and that by not widening the review and at least offering the client that choice, that there was a potential for say the firm that worked on that bad deal that Rita kind of cleaned up for to go after their firm with the wrong client in the wrong situation. So I think that something like that could play out. And I think we'll see it used ubiquitously. I don't actually know how much it'll really change the fundamentals of M&A, right? Like it's just another way to get a deal done, but ultimately like you're just trying to get a deal done in the same way that like DocuSign or Zoom probably was a big change in doing deals. I don't think DocuSign was, apart from as a seller, it's a or buyer, it's a much more pleasant process than it would have been like having to sign all this stuff in one go. And one just slight change to what Mike was saying, I don't actually think it's the systems that need to evolve so much in order for that sort of ubiquity of software to come to the front. That actually it's more firms evolving. Like there are firms where it's pretty ubiquitously used, firms where it's not, and I think it's more just behavioral change than it is technology change, I believe.
Great. Well, again, thank you everyone today for your comments and your commentary. It was really insightful. And to our audience, thank you for joining us.
Thanks, everyone. Good talk.